she is a former teacher and also a law clerk with our office this summer, and we are both very excited to share this webinar with you. The webinar is called Your Child's Rights to Stay in School and What You Need to Know About School Discipline. The webinar is really geared, we're trying to gear it towards a parent audience and also to organizers and others who work with parents in the field. So we're going to, some of the material we're not going to get into as depth, but we're going to try to cover a lot of topics today, and we're going to make it a bit interactive as well. We're going to have a few polls. So when you look down the little screen bar that's showing up, you'll see there's a place to chat. And right now when you chat, you can write your name into the box there or write a comment to us and the organizers. Right now you're just chatting with the organizers. We'll be able to see any of your comments and questions also. So if you have questions, you can put those in the boxes. And at some point, we also are going to try to open up the chat function in 1 or 2 spots so that you can all see each other's answers and chat with each other a little bit. And then we'll also be asking you a couple polls to test your knowledge. Nothing too difficult, but things just we want to make certain that it's clear what we're saying and also get your feedback. So again, after the webinar's done, just a few housekeeping things. You will get an email with this PowerPoint and with a copy of the webinar, and so you'll be able to share that. And we also hope that you'll go to fixschooldiscipline.org and sign up online to be registered to receive other information about webinars and research and tips and action. And there'll also be a survey at the end, and we'd love for you to fill it out to tell us how we're doing. So we're going to get started now. All right, so first, why are we here today? We're here today to talk about discipline and about removals from school, and it matters a lot to students in California, and it will matter to your child. And the reason for this is that there are real consequences that come when young people are removed from school, and the research really shows that when a young person's removed from school, it can really impact their ability to graduate and to go on to higher education. And so we want to pay real close attention to what's happening with discipline and really help to try to keep as many children in school as possible. In California, at least last year, we issued over 500,000 suspensions, and 37% of those were just one category, willful defiance and disruption. And it can be, willful defiance and disruption can be for a number of different things. It can be for not having a hat on or not wearing proper clothing in class. And what we find also here, as you can see in the data, is that we have disproportionate suspensions happening. And what that means is that, for example, our African American students in California are far more likely to be suspended than any other group. And nationally, we also see that our students with disabilities are 2.5 times as likely to receive a suspension than other groups. And the data shows that they are 81% of the young people in our schools who are being physically restrained. Similarly, students with disabilities make up many of the young people, too many of the young people who are being referred for law enforcement and for arrests from our schools. And 70% of our students of color, are those who are recorded as being arrested from our schools. And why does it matter, right? Because if we were actually suspending young people and it resulted in better behavior or a greater likelihood of them finishing school, then the suspension data wouldn't be so significant, right? But what we've seen and what the research has shown in the last 2 decades is that young people, and particularly in a very strong study that came out of Texas that was over time, showed that young people who have been suspended even once are 6 times more likely to repeat a grade, and they are 5 times more likely to drop out, and they're 3 times more likely to have contact with the juvenile justice system than other young people who have not had that happen. All right, so what we want to talk about today is what are some of the protections that young people have under the law before they're being removed from schools. Okay, and so there are a number of different protections, and there are also, there are also additional rights for our students with special needs and with disabilities. All right, so this is, many of you have probably know of a young person who's had one or more of these things happen, or have heard of someone, or maybe even work with a young person, or your child has had this happen. So we have on here, first of all, detention. Detention is something I know. I had detention when I was in kindergarten and in first grade. It's an hour, right, in California, and the law talks about it being for an hour at maximum, and that it should not be during recess or lunchtime. And also the law says that there should be no hazardous work. Now, I'm sure there was something that happened where children were being applied to do some sort of hazardous work, but I don't know what the specifics were, but those are the requirements. And then, of course, there are office referrals, teachers sending students out of the classroom, and there are limitations on those, and we'll talk about that a little bit later. And then the big one, which is the suspension, right? The suspension can be a suspension out of school, sent home to your house. You know, a parent gets the phone call, you need to come up and pick up Johnny, and you know, he's being suspended. The suspension can also be in school, an in-school suspension that's supervised, or say, well, you can't be in class today, but we're going to suspend you in school. For both of these, it cannot be more than 5 days per incident, right? And throughout the year, you can't have more than 20 total days of suspension. You can't issue that many, except if folks, can you still hear me? Just want to make certain that folks can still hear me. I just got a message that somebody cannot hear me. Can everybody else hear me? Yes, okay, great. 30 or more than to 30 days if it's a school transfer. And in addition, we're going to talk a little bit about voluntary transfers. So you may know of a young person, or maybe your own child has been transferred to another school placement, to an alternative school placement outside of maybe the neighborhood school that they're in. And then the last thing we're going to talk about for a bit is expulsion. And that is when a child is removed from the entire school district. If they are in fact expelled, it's really, in my mind, the most serious type of removal, and it can be up to a year in time. And there are other rights that go along with that, including a formal hearing and a rehabilitation and readmission hearing. So those are the primary topics we're going to cover today. All right, next slide. All right, we're going to do a little poll. I just went over a lot of things for you, and so we're going to test you. All right, so we're going to check in. So the first question that you have, sorry, one second. The first question that you have here is it okay for your child to be held for detention? We're gonna during lunch, and so we're gonna open that up and launch it, and we're gonna give you a few minutes. So go ahead and click your answer, and we're getting some people are saying no, some are saying yes, as long as they can eat lunch. We've got 75%. Almost everybody's voted. Get your last vote in. All right, we're going to close the poll. We're going to show you the results. Share. Okay. So 30% of you said yes, as long as they can eat lunch, and 70% said no. And the answer is no. They cannot actually be held for detention during lunch. I remember, I think that was a pretty common practice when I was growing up. But the answer is actually no. All right, the next one we're going to do here is it okay for a school to suspend your child for 6 days in a row? All right, go ahead and enter your answer there. Great, people are answering. Right now we've got 75% saying no, some are saying yes. Depends on why they were suspended. All right, very good. We're going to close the poll, and we'll share it with you. So we have a mix of answers here. So 67% said no, it's not okay for the school to suspend your child for more than 6 days in a row. 22% said it depends on why they were suspended, and 11% said yes. So this is kind of a trick question. Very good. So not surprising, we got some answers that were different. So the first answer is that no child can be suspended for one incident for more than 5 days in a row. That's the first answer is no, except, there's always an except if the child is referred for expulsion. Okay, and if the child is referred for expulsion, then they can extend that suspension to 30 days to hold the hearing for expulsion. Okay, but in general, doesn't depend on why they were suspended. In general, though, unless there is a referral for expulsion made, a child cannot be suspended for more than 5 days in a row. Okay? Good work, everybody. All right, so let's talk a little bit more about suspensions here, because this is the one that, that we get the most calls on in our office and have the most concerns about. And I'm going to pass it over to Elena, and she's going to talk to you about suspensions.
Hello, everyone. This is Elena Fresquez, former teacher and current law clerk. I want to encourage everyone to remember that if you have any questions, we understand this is a lot of information, and please feel free to write those down in the chat as we go along, and we'll try to get to you as soon as possible. So the big one, suspension. So there are a lot of different kinds of suspension that we wanted to go over with you today. And the first one is teacher suspension. Now, this is a suspension where the teacher refers and the student can be suspended for up to 2 days. The teacher is required to ask for a conference with the parent to address whatever issue that the student was referred for suspension for. The second one is an in-school suspension. This one requires a conference with the principal, teacher in class, and counseling. The parent needs to be notified in writing if for more than one period. So if the student asks for work, the teacher needs to provide it. So if the student, can't just be sitting there while they're suspended, they need to be doing work, working towards whatever they are missing in the classroom while they're in school suspension. The third type is the out-of-school suspension. This is the one where, you get the call to come pick up your student. There is a student conference with the principal. There's required when there's an out-of-school suspension, also a written notice, and of course contacting the parent, which is especially important because you need to come and pick up your student. So that is the fourth. There's a third kind. The fourth thing we need to know is that suspensions can only be for offenses in California law. This means that your child cannot be suspended for truancy or tardiness or absences. These are all areas that are not covered in California law, and your student cannot be suspended for them. So if the school tries to suspend your child for that, that's something that definitely you need to understand is not allowed, and definitely address that with the school. And last but not least, the act must be related to school or a school activity. Now, this can include coming to and leaving school as long as it is related to school. Now, this also in the digital age with electronics and electronic bullying, etc., those are things that are included in relating to school, even though they might not be happening at school or a school activity. They are related to school, so those things your student can be suspended for.
For those, there has to be a specific impact of whatever that activity is in the school, and there's some specific requirements about that for the online electronic pieces.
So what offenses can a student be suspended for? Well, here is a list, and you can actually find this in the California Education Code. There's a whole list of different offenses, including physical injury, weapons, illegal drugs. You can read the whole list here. These are the offenses that students can be suspended for. Again, if they're things like tardiness, truancy, absences, those are not things that your student can be suspended for. So just make sure to kind of have this list in mind if your student is suspended from school.
And there, if you look in the code, it's almost 24 things, and right here we've just kind of condensed them down so you can see the big ones, right? So, and you can note here that some of these things are things you would expect: damage to school property and stealing. And then there's the willful defiance and disruption, which we mentioned is still 37% of all the suspensions in the state. And then there's, the ones that you would anticipate: bullying and harassment and sexual assault. So those are the big lists. But again, if it's not in the list, you cannot be suspended for things that are not specifically in the education code. And someone asked a question: is the parent required to be at the student conference for an out-of-school suspension? And what is required to be discussed during that conference? Excellent question, and we're going to answer it in just a minute, but I want to let that person know we've got it, and we'll be answering in just a second.
So when can a student be suspended? So obviously we gave you that list of different things that a student can be suspended for, but what we want you to understand is that all other means of correction fail to bring about proper conduct. That's when a student is going to be suspended. Now, of course, there's an exception, but first let me talk a little bit about other means of correction. When we say that the first line can't be, oh, your student messed up, suspension, unless they committed a zero tolerance offense. So we're talking more specifically about what a zero tolerance offense is, but often that it has to do with students being a danger to others.
So the exceptions are, you have to exhaust these other means of correction unless the student has either committed a zero tolerance offense or the student is found to be a danger to others. So it's a little confusing here, but this should say, or these are the two exceptions to the other means of correction. And this is important. The other means of correction piece is very important, and we'll talk about that in a minute, because a lot of times young people are not receiving other help before they're suspended, and we want to make certain that we have really good solutions in place before we actually remove them from school because of how serious that removal is as a consequence on their future and their future learning options. And someone else asked a question here really quickly. I'm going to answer this one. Can teachers keep students in class during lunch to make up work? The code is silent about that because making up work is not necessarily a detention. It speaks specifically about detention. So it's possible that could be the case. In such a case, you couldn't be depriving the student of eating lunch or anything like that. Can districts get around the truancy exception by suspending students for willful defiance, for being truant after they've been told they shouldn't? We know that this happens. We know, we've heard this happening before, that sometimes students are suspended because they've been told they cannot be truant, and so then they are now willfully defiant. I would say that should not be happening, particularly also because what we have here, right, is that other means of correction need to be used in advance, and that it is kind of a tricky way of suspending someone for what is in fact truancy. And so if it was a child who came to us, we would say that should not be occurring, and really we know that it also does not make sense to send a child home who already is missing school. What we want to do is bring that child back to school, find out why they're missing school in the first place and being truant, and try to create a welcoming and supportive environment to bring them into the classroom. Removing them for more days is only going to put them further behind. Great questions. Okay.
So we mentioned other means of correction. So what are these other means of correction? The first two listed there, positive behavior interventions and support and restorative justice, are two areas that we're going to go into more detail later, but basically these are other ways for us to, alternatives to suspensions, which are basically focused around encouraging positive school climate, encouraging kind of trying to address these things before that they happen, and if and when they do happen, to look at it as a way to address the underlying issues that are manifesting in the behavior, not necessarily all about punishing and kicking the kid out of the school, because as we heard at the beginning of this presentation, kicking kids out of school, suspensions, expulsions are just going to lead the kid down and further down and hurt their academic achievement and the overall school climate. So there are other means of corrections, which include counseling, after-school support, conference with parents. All of these things are ways to talk to the student, bring in the parent, bring in ways for us to understand what the child needs, what they are missing, how we can all come together and address these needs before it escalates to a point where the student is forced to leave the school. Then there are referrals for IEP Section 504. We'll be talking a little bit more about that later as well, but sometimes when a student is acting out, there can be a reason for that, and that might be that they're just not understanding what's going on in the classroom. When I was a teacher, I had students who acted out a lot, and it turned out that it was just because they had certain disabilities that we weren't aware of, and once they were able to receive those services and supports through an IEP or Section 504, they were able to get the support that they needed, and the acting out in class definitely decreased. And then there are full assessments, which
so there could be other types of evaluations and assessments that a young person could get, not just for an IEP plan, but you could have a multidisciplinary team where your mental health counselor at the school and a social worker, or you bring in someone from the outside to figure out what other services not only the child needs, but maybe the family needs. Because sometimes, you know, we have clients or young people that we work with, maybe the parent is homeless, and really part of the acting out is because they don't have a safe place to live at home, or they're living in their car. And so there are other issues. Sometimes it's related to trauma, and so we want to make certain always to try to figure out what's happening and put in place a strong plan with that young person that doesn't look at it's not a blame model, but a model of support and intervention and increasing help for that young person. Okay, we'll go to the next slide.
So we've mentioned willful defiance and disruption earlier, and from your last question, can districts get around truancy by suspending students for willful defiance? You're definitely kind of understanding that this is a very kind of subjective and also very often manipulated definition. So AB 420, you'll see at the top there, actually was put into place recently to address the fact that willful defiance and disruption was being used very subjectively, and in a lot of cases just too broadly for things like, you know, failing to take off a hat or disobeying teachers. That was a way that you could, you know, expel students, which definitely, you know, there are other ways, as we've talked about, other means of correction that could definitely address those things. The student doesn't need to be expelled for something like that. So under AB 420, only students 4th grade and up can be suspended, which means that students K through 3 cannot be suspended for things that fall under willful defiance and disruption, and no student can be expelled for willful defiance and disruption in California. And that's, you can see the California Education Code that we put on the bottom, 48900K. And it's important to know that students above 4th grade that can be suspended can only be suspended after other means of correction have failed. They must try other things first, things we talked about on the previous slide, counseling, after-school supports, restorative justice, things like that, before that they can suspend students for these kinds of things.
And so and just to clarify a little bit more, so the new law went into effect in January, and again, if the child is in kindergarten, 1st, 2nd, or 3rd grade, they cannot be suspended in school under a 5-day in-school suspension or an out-of-school suspension for willful defiance and disruption. And they also, no child from kindergarten through 12th grade can be expelled for willful defiance or disruption. Okay. There's a whole nother class of things, right? That's not just about suspension, but also about teacher removal. And so maybe Elena, you can talk about. I'm sure you removed children from your class and sent them to the office and those types of things.
I did. I actually I did all of these things when I was a teacher. You can see the 3 different things that you can do besides the suspension. Putting a student in another class for the day. Very often teachers have these kinds of buddy classrooms where they decide, you know, this kid is just, it's too much for me today, can you please take my kid? They're usually put in the back of the classroom. You send some work for them to do, and they're isolated. You can refer a student to an employee designated to advise the pupil. So perhaps someone who is a counselor, someone who they regularly might go and see. I had behavior counselors at my school who my students might go to. And then the 3rd one is removal from class for the remainder of the period. So that might not be for the entire day, just for one period. But as you can see underneath, there are limitations that can't happen more than once every 5 school days. And again, we want to emphasize that there are other means of corrections that really should be in place before this. I know that, you know, while better than suspensions, these are still a way of removing the student from the classroom, removing the student from learning, and this can have really detrimental effects to the student, because it sends the student the message that either 1, the teacher can't handle the student, which is not good because then the student doesn't feel the structure and support that they need in the classroom. They feel the teacher can't handle them, and often that encourages them to act up more. And two, you know, the student basically feels like the teacher has given up on them. I know one incident when I was teaching, I had a student that I just, you know, had a really rough day, and the student just kind of wouldn't stop talking and wouldn't stop talking out of turn, and I kind of just yelled at him to get out of the class, sent him to the buddy room, and felt really bad about it the next day. The next day, that student, who was usually very kind of upbeat and outgoing, was very sad and depressed all through the school day, and I could really tell. And I did have a chance to talk to him afterwards, and he told me how hurt he was and how he felt like I had, you know, given up on him and didn't want him in my classroom anymore. And that wasn't at all the case. I did, you know, very much care for that student. I just wanted to make sure, you know, that these students feel wanted in the classroom and want to stay in it.
And we're going to talk in a little bit about some of the things as a parent or an organizer or a community member or an educator you can advocate, because we want to make sure that teachers have all the tools and supports they need to help those young people and keep them in the class. And there's some really good research-based tools and training and supports that we can do to make certain that fewer of these types of removals, office discipline removals, happen so that we don't lose track. So we're going to do another poll. We want to keep you all engaged here, and let's try this one. All right, see how we're doing. Hold on one sec. All right, do you have a child, or do you know, let's see, did it work? No, or do you know a child who has been suspended? Go ahead. Oh, yep, we've got 100% so far. Yes, they do know a child who has been suspended or have a child who has been suspended. All right, we'll close the poll in just a minute. Click in if you haven't yet clicked to tell us if you do. Still 100%. All right, anybody else want to vote? Give you a minute more. All right, we're going to close the poll now. We'll show you the results. Not surprising. Everybody who voted, 100% said yes. I do have a child, or I know a child who has been suspended. All right, we're going to do another one. So hold on one sec. All right. All right. And what about to the office? Do you have a child or know a child who has been sent to the office? Yeah, everybody so far who's voting is saying yes, they do. Pretty common occurrence still that everybody here does know and has experienced this or knows of a young person who has experienced it. Okay, we'll give you 2 more seconds to vote. Great. And here's the results, 100%. Folks, all right. So we have some work to do still to keep more kids in class, I think is what that lets us know. All right, so how many days? We talked about this before, and we'll do this real quickly, but again, not longer than 5 days for any one incident, right? And then we talked about the exception before, and you guys learned about that, which is that for the child recommended for expulsion, there has to be another meeting with the principal and the school, and then they can extend it. Waiting for that hearing, waiting for the expulsion hearing. And then the second one is it can't be longer for a total of 20 days for all incidents in the school year. And then again, that exception we talked about before, 30 days for students who transfer to another school. All right. What are the out of school procedures? This goes back to someone's earlier question. So before a child is suspended, the child is entitled to an informal conference with the principal, and that is really important because that's when the child is supposed to be given a real opportunity to be heard and to provide their evidence, right? There's an exception to that, which is an emergency situation when there's a clear and present danger, right? So there has to be a clear and present danger of keeping that child on the campus, but otherwise there should be time to have that young person come to the principal's office or their designee and to hear what's happened and to hear from that young person so that we, there's a real opportunity for them to say, look, I want to know what happened, why you're about to suspend me, and I want to be able to give my side of the story. The parent is supposed to be notified at the time of suspension. This is very important. We've had situations, unfortunately, where a parent was not notified. Parent and student was actually just asked to leave the campus. And that's not safe, obviously, and it's critical that the parent is actually notified. And then the conference that someone asked about, what happens at the conference on return? The conference with the parent is actually upon return generally. So that's the parent meeting occurs upon return. Sometimes it happens on the same day when that parent gets there, right? The parent gets there and there's another conversation with the parent and the child before the suspension happens. But under the law, it's the right to a parent meeting upon return. And we would say it's really important to go to that meeting, to really hear more, to find out what's going on, and to ask for a plan of support and for help for that young person if they're struggling. If you think that it was not a suspension not fairly given, it's an opportunity to ask for a right to appeal. And in schools where they are doing restorative justice, and more are doing it, and we'll tell you about that in a minute, hopefully they'll have also an opportunity to set up a real reentry type of restorative conference to really bring that young person back into the community. And you heard from Elena that, this has a real effect. It's not just, young people are very hurt by this, and it helps to weaken those attachments with school, which is part of the reason that we see that higher dropout rate for young people that have been suspended. And on return, there's not specifics about what's supposed to happen at that meeting, and if a parent cannot go, you cannot keep a child out. So if a parent doesn't show up at that meeting, it's not a reason to keep a child out after the suspension days have been finished. All right, can the child's disciplinary record be amended? And the answer is yes. You can appeal to have a record amended for an improper suspension. There's a particular ed code, California Education 4907. We have on Public Counsel's website some forms that you can use that already you can use to actually appeal that suspension. Obviously, suspension is 5 days, and so the appeal most often does not get done while your child is being suspended, but the timelines are longer than that for removing the record. And why do you want to remove the record? Because it can have an impact, having suspension on the record could have an impact in other schools, and also it could have an impact in terms of applying to college or things like that in terms of when they look at the record. So if it is improper, then you should try to get the suspension off the record. And some school districts have procedures also for local appeals. So you want to go onto your school district's website and search around and see if it says, here's the process for appealing a suspension in our district that's different from the state law. All right, involuntary transfers, and we're going to try to do this pretty quickly because there's a lot of different ways that a child could be involuntary transferred, and there's rights. Okay, so an involuntary transfer refers to a continuation school, and these are schools that are really supposed to be set up to give an academic assistance to meet graduation requirements for young people who are not close to graduation, right? And so they're only for students who are age 16 or older. That's very important. And they can happen involuntarily, meaning the school district can make a student go when the student commits an act for which they can be suspended, right? And or frequently truant, and if other means of correction have failed. So except for the exceptions that we talked about before. So those are the reasons for it. And then we have, if a student is transferred, they have written notice, and they also have a right to appeal before the transfer. And such a transfer can only be for 2 semesters total. So this is important because we've had young people who've said, oh, well, I was told I could never come back to my high school in my neighborhood. And that shouldn't happen. It should only be for 2 semesters, and really when a person is at the continuation school, a young person's there, they should be really working to make up their credits. And someone asked, can students be involuntary transferred solely because they are low on credits? The code says no. No, the answer is no, not just for low on credits. They will often be counseled to go, and so they can be voluntarily transferred there. And sometimes that is a good option for a young person who's very far behind, for them to go to continuation school if they are able to do work more independently. Some of the continuation schools operate differently, but many of the ones I've worked with, they have kind of a packet type of system. They do have a teacher there who's working with the young people, but for some people that system of kind of independently working doesn't work for them. So you want to always, if you're a parent, you want to go check it out and see if it's the right system for your child. And if you are, work with young people in the schools, same thing. You want to check and say, well, is this going to be the right thing for my child? Will this work out for them? All right. Another type of school is the community day school. These are schools that are set up by school districts. The school district creates these, and students can be transferred when they are expelled. So a student who's been expelled might be transferred to a community day school within their district. Also, if they are on probation, there could be a referral made to a community day school. For young people who are on probation and are being referred, it's important to know that the parent still has rights, and in that situation, the parent would need to sign off on that transfer unless a court has ordered it. And then a school attendance review board can make a referral. They could make a suggestion for a referral there. And there's a question as to whether that can be an involuntary transfer in that situation. If the board has ordered it, generally the code says they can make that referral. And then there may be a district level referral process, some sort of policy that the district has come up with, and that can differ. One of the important things is to know is that if the child was not sent to the school for one of these reasons, the parent should, and the parent doesn't want a child to go to the community day school, they can contest it in writing. And if a child's not doing well there should be communication back with the school district about whether it's working or not and what the results are. Some community day schools are really great, and some may not have a lot of the resources that a child may need. So again, as with any school, parents should go and check it out and see if it works for them and if it's the right fit. Next slide is involuntary transfers to the county community day school. The county community day schools are, as it says, they're run by the County Office of Education, and many children are transferred there because the children are often transferred there when they are actually expelled. And the second reason they're transferred there is if they're being referred by the school district after the Student Attendance Review Board. And a Student Attendance Review Board is a process for, as you can hear for a student, that it's a process, is a process where students are, having attendance problems, and so they are being transferred there because of those attendance problems. Now, we have had in the past young people who've been transferred, and as a result, there wasn't space when they got there, or the transfer was to a county community school that was very far away, and so they actually couldn't really get there. Or the place that they went to didn't have an IEP process that supported them. So in all of those situations, that the transfer cannot be effectuated, and so we want to make certain that any young person who is being transferred is able to actually go to the school, that the county community school can meet their educational needs, whether they're an English language learner or they are in special education, that the parent can actually get there, and the parent is allowed to provide some sort of reasonable objections as well. The other thing here is that under a new law that was just passed, if we can talk about this, actually we'll go talk about that in a moment. All right, so now we're going to talk about expulsions. All right, and how's everybody? I hope everybody's doing okay. It's a lot of information, so we'll keep on going, and please ask any questions that you have in the chat box there, and we really appreciate the ones that have come in so far. All right, so expulsion. So again, for all those reasons we showed you at the beginning for which a child can be suspended, they can also be expelled, right? So except for willful defiance and disruption. And once a recommendation for expulsion has been made, then that 5-day period we talked about can be extended to a maximum of 30 school days. And only the school board may expel a child. And when the expulsion happens, it's for a maximum of 1 year. It can be for a maximum of 1 year, and during that time period, the child is entitled to be in an alternative education setting, so they're not out of school, they're just in an alternative education setting, often the one we just talked about, the county school. And you have a right to, before this happens, because it is very serious, a notice and a hearing. You have a right to an appeal. You can bring an attorney or an advocate, and we think it's, for young people that are facing expulsion, it's very helpful to have an attorney or an advocate. So you want to reach out to your local legal services organization and ask them who helps young people with expulsions. If you know of a child who's being expelled, Those are the basic pieces for expulsion. All right. And so there are different levels of discretion in terms of whether an administrator or a principal can actually make a recommendation for expulsion and whether that school board has to expel. So the one thing there's a lot of details in this normally, but for this purpose today, the thing to just remember is that there's a few offenses for which a principal, if it has happened, the principal must recommend, and the school board, if they find the student did it, has to expel. Okay, and that's for the very serious ones that you might think. So possessing, selling, or furnishing a firearm, right? Brandishing a knife, and it has to be a knife of a certain size, and you have to be taking it out and brandishing it around. Unlawfully selling a controlled substance, so selling specifically. Committing or attempting to commit sexual assault or battery, and possessing an explosive device. Now, there are situations, these all sound very serious, but we did have a situation, a case that we've heard about that's, yes, the zero tolerance items here are applicable to suspension. So the principal in these situations, these are also the zero tolerance offenses for which they must be suspended, right? So if these happen, then a principal must recommend the expulsion, and then they also will most often suspend for 5 days, but there's no requirement to. They could suspend for a few days, but they must make that recommendation. So ultimately, unless there's some you find out that it's not true, they will most often be recommending them directly for the expulsion board. Now, if it's not one of these zero tolerance offenses, the principal of the school board have discretion not to expel, right? And so these are the big ones. So again, we had a case that we heard about where it was a young boy in elementary school, and he had patted a little girl on the butt. So the definition of sexual battery is very broad. In that situation, the school district felt like that was in fact a sexual battery. Now, we would say no for reasons of intent and all those types of things. But it's important to know that in these situations, it's always important as a parent, if you're working with parents or you're an organizer, or you're working with parents who are struggling with these things, to go with them to these meetings, talk about what's really happened, find out what the facts are, and again, to see if you can have an advocate come with you to a meeting like this. Now, if an expulsion is being considered, can my child continue going to school? So there's a question after that 5-day period, at that 5-day extension of suspension conference, which will happen, right? So the principal will call and say, all right, we've recommended you we're thinking about recommending you for expulsion, come on back, let's have a discussion about this. Okay, we're going to discuss whether we're going to actually send you off to a school board hearing, and at that point in time, we have been able to, at meetings like that, been able to talk to a principal when it's in their discretion and say, there were other, we need to help this child for other reasons, or, please don't recommend them for expulsion. Let's come up with a plan together for rehabilitation. Let's do something else. And the question that the principal will be looking at, not only are those types of mitigating factors or whether other means of correction would work, but also will the presence of the student cause a danger to persons or property or a threat of disrupting the school process? So those are the questions they'll be thinking about. And again, the parent and the student have the right to participate. And the results could be, like I said, that there's a decision not to refer for expulsion. Sometimes there might be a discussion about, well, instead of expulsion, let's talk about maybe involuntary transfer. And it could also, again, result in that expulsion referral. But that's a very important conference, and we always encourage parents, if they need to come with an advocate also to that. Expulsion hearing timeline. So it's fast, right? So once you have that, it's 30 school days from the original date of suspension that you have to have that board hearing. And that is very important. That is jurisdictional. That means if the school district does not hold that hearing within the 30-day timeline at 30 days, the expulsion comes off the record after that. So if it's day 32 or day 33, they have to get rid of that expulsion, and they need to drop it. And the reason that that's such a serious thing is because 30 days is a long time to be out of school, right? A long time to be out of school, and at that point you've really lost much of your semester. Most young people are going to be really far behind. So if we're going to do this, we have to make certain that it's done quickly. And the child and the parent are the only one that have the right to postpone that hearing, right? They can postpone it as a matter of right for 30 days, and some of our clients really want to do that because they're not ready. It happens so quickly they're not actually ready, and you can tell the school district you want to do that. What happens during that expulsion hearing, right? So there's a panel, administrative panel for that first hearing, and they have 3 school days to make a final decision. And if they decide not to expel, then that decision is final. So if that panel says, nope, we think we don't need to expel, it's over, it's done, and the child gets to go back. If they recommend expulsion, they have to submit those findings to the school board, and then the school board makes a final decision within 40 days of that original recommendation for expulsion, right? And that hearing before the school board, it usually happens in private, but then they announce the result in the public hearing. And again, it has to be 30 school days from that original expulsion recommendation, and they get 10 days to make the decision. So everything happens pretty fast in general in the time of adults, but for the time of a young person, it's still too slow for them because they're missing so many days of school. All right, and what happens if your child is actually expelled? If you're the parent, you will get a written notice. It must be sent to you. It includes this right to appeal. It's not over at that point. Even when your school board says you've been expelled, you get to appeal to the County Office of Education, and we really recommend that parents do that. Again, we recommend reaching out to see if you can find an advocate or an attorney to help you if you are a parent, and you have a right also to go into an alternate educational placement, and you have a right to what's called a rehabilitation plan, and that's a plan that's created to try to obviously help address whatever the issues were that led to expulsion, and then you will need to meet those requirements to be readmitted. There'll be a readmission hearing after that for readmission, and the parent and the student need to show up for that to ask to come back into the district. And if the parent wants to move the child to another district, then the other district must be informed of the expulsion. Okay. Can you appeal? Yep. Just as we said before, yes, you can appeal to the County Board of Education, 30 calendar days, and they have to do it fast too within 20 days. Okay. So the big thing here is just to remember, there's a lot of details here, but the big thing to remember is that there are a number of steps in this process to make those arguments and to try to ask to be returned to the school. And again, as if the appeal fails, then these are the processes we just talked about: the rehabilitation plan, the readmission. The governing board goes through a readmission hearing, and that they have to readmit you unless you didn't meet those rehabilitation plans, or they make a determination that your child still poses a continuing danger. Right? And they have to again provide you with a reason for that, and you can request that your records be expunged at that point as well, which is a positive thing, and we always recommend that you do that. I do want to note that if your appeal fails to your County Office of Education and you still believe that it should not have happened, you also can go to court and continue to appeal it in the court. All right, let's do another quick poll, see how we're doing. All right, so what must happen before a child can be suspended for swearing and tagging a book? What must happen? Hearing in front of the school board, the school has to try other means of correction, an informal conference between the student and the principal, or both B and C. Great, people, we've got 64% are saying B and C. We've got 36% saying the school must try other means of correction. A couple more votes. We'll keep it open for about 3 more seconds. Anybody else want to vote? A couple more votes here. All right. Good work. All right, so we have a mix. We've got 64% said both B and C, which means the school tried other means of corrections and there was an informal conference between the student and the principal as things you'd have to do. And that is correct. Again, that is absolutely correct. That because swearing and tagging are not those zero tolerance offenses, and a child who does those are not posing a danger, that there should be other means of correction have been tried and exhausted. And also there has to be that informal conference between the student and the principal, right? So both of those things should be occurring. So there can be a discussion, and one of the things you could bring up in that conference is, I'm not You haven't given me any chances to have other means of correction. I'd like to do something else. I'd like to do community service. I'd like to have a restorative justice conference. I'd like for there to be other things tried before you remove me from school. All right, and we have a question. Can a dean replace a principal in the informal conference before a suspension? I believe that the code says a principal or his designee. And so that the person could be, the designee could be the dean, but I want to check that. I'm fairly certain in my mind that that's the case, but let me check that before this is done, and we'll give you the answer. All right, alternatives to suspension and expulsion are a win-win. I'm going to hand this over to Elena.
Okay. So we've been talking a lot about alternatives to suspensions and expulsions, and again, how important it is to keep the student in the classroom. And this slide, as you can see, has a bunch of different illustrations of win-win, but really the way that we see it is a win-win-win-win-win, because we see this helping students, staff, and not just students who are the ones being suspended and expelled, but the student body as a whole. And these alternatives, we're going to see in these next few slides, are really a way to create an overall holistic, whole school, positive school climate where all students are able to succeed and teachers want to be there, administrators want to be there because it's such a positive school climate. So the first thing we want to look at is school-wide positive behavior interventions and support, which is also known as PBIS or SPBIS. Somebody's saying that they're still saying the, all right. Oh, so you missed here.
You missed the pretty slide.
You missed the win-win. Here's the win-win-win slide I was talking about. You all probably were like, what is she talking about? So here are the win-win slide, and here is the slide on school-wide positive behavior interventions. So this is, again, going back to the need to create a positive school climate that will help all students. And so you can see on the left, there's this triangle that starts at the bottom with all students. And the way that we can have a positive school climate is definitely going to help all students. And this is the level where these are things that sorry, one second. Sorry. So this is the level where all students are helped at the bottom here. And this is something where school climate is helping everyone to succeed, because overall the school has these positive behavior interventions where students are routinely praised for doing great things instead of constantly just being punished for the negative. So students are constantly on a day-to-day basis being rewarded, acknowledged for positive things that they are doing. So this is something that is targeted for all students. We want all students to feel safe, supported, acknowledged at school for the good things that they are doing, and not just wait for them to mess up. And then
and in a PBIS school, you will see a number of things that include that on that first level, that you'll see that teachers are receiving trainings and providing explicit teaching on social emotional learning in the classrooms. You'll see around the school that up on the walls there will be the 3 or 4 big expectations that everyone's for, and they're framed in a very positive way, and that everything will be working together in terms of everybody at the school will be on the same page about providing those positive rewards and also the expectations, and throughout the campus, young people will know what those expectations are, and the adults will be modeling and framing those expectations as well. And then you have here these different levels of intervention, so targeted and then intensive. And so if there are young people that are still struggling and the universal interventions are not helping them, then there'll be additional interventions and supports for them. And there's database decision making as well for trying to figure out, for example, at one of the schools where they're doing PBIS, they started looking at their data and they realized that right after PE was when they were getting most of their fights, and that lots of young people were being suspended and getting in-school suspension. And so they just recreated the way that they had their class scheduling, and they stationed some more adults out there, and they basically reduced a number of their suspensions just by taking a close look at their data. And in the supports part, they did great work of targeting where they saw that some teachers were struggling more and having more removals and more suspensions. They put more mentor teachers to help them. They had counselors scaffolding into the rooms. And for the young people who needed extra helps, they had different levels of support. So, lunch with the principal or work with a counselor or the parent coming in and helping. So whole level of different types of things that you can do in PBIS.
And the things that we've seen is that at schools with PBIS, where these expectations are predictable, consistent, actively monitored, that these schools that implement PBIS see a reduction in suspension and office referrals of up to 50%. And schools that have PBIS, this positive school climate is also associated with academic gains. Students are feeling more safe and supported, feeling like their hard work is more acknowledged, and it reduces the rates of dropouts, and it encourages higher teacher retention, because again, this is a win-win-win-win. The teachers are winning here because they are also a part of this positive school climate. It's something that I know as a teacher I definitely would want to be a part of, as opposed to just the suspensions, expulsions, traditional kind of discipline.
Okay. And we have an expert, actually, a very well-known national expert on PBIS who's actually joined this, and that's an honor, Jeff, to have you involved. He's noting that some of the continuum consequences actually that are involved in some of the implementation of PBIS can be a source of weakness in terms of reducing suspension, and I know that there are a number of folks working on that.
So restorative justice is another alternative to suspensions and expulsions that we are talking about. So it's great to have this positive school climate to try to prevent things from happening, but things do happen, and what we want to try to do with your restorative justice conferences, restorative justice circles, are basically find a way to not just punish the student, but to address the harm that has caused to the affected person, the student, and on a larger scale, the school community as a whole, because again, this is a holistic, whole school approach. And what we want to do is we want to focus, again, not on who's guilty or how are they punished, and we want to focus on the student taking responsibility in an environment that's non-punitive, in an environment where they can sit down in a conference, in a circle, and really talk about what happened and talk about how they can repair the harm that has happened. This is not about blame, shaming, or fear. This is about getting students, teachers, the community together to understand that there's a different way to approach this, and a way that's healthier for everyone, and a way for everyone to have buy-in, so that it can, again, create and foster this positive school climate where students can really feel safe and supported.
And one of the really wonderful folks who's implementing restorative justice in Oakland, Fania Davis, told us a story about a young person who had, basically, had committed, an infraction with regard to something sexual, sexual conversations with another young woman at the school, and saying things that were inappropriate, and really it had hurt that young woman very much. And both the person who did it and the person who were affected by it were willing to get together in a restorative circle, and it has to be voluntary. And through that, the consequence that everybody thought was not the consequence, but the decision that everybody made about what would help to affect that harm, was that young man did a whole research project on sexual violence, and also on sexual stereotyping, and wrote a paper about it and gave it to the class, and also wrote an apology note. And both young people really benefited a lot from that. And it was not what would normally have happened, which would have been a suspension. And in that case, they were able to also have a relationship, and it created a stronger community. So that's an example of something that can happen with restorative justice. And also with restorative justice, it's not just about addressing harm, but at the universal level, the same way as PBIS, you can create community by having restorative circles where everybody comes together in a circle to talk about and create, for example, classroom culture and classroom climate, and agreements about how everybody wants to be treated, or even just to do a check-in. How's it going today? What's happening? To create those kinds of strong relationships, both between the students in the class and the parents. And that creates a culture of prevention and helps to address a lot of issues. A couple other strategies.
So here's a few more strategies, and the first one, anti-bias and cultural competency training. So earlier we talked about willful defiance and disruption and how kind of subjective that can be, and often willful defiance, there is a disproportionate amount of students who are suspended, who are students of color, or we talked about earlier, disproportionate amounts of students who have special education needs. Now, when we talk about race, bias, and culture, very often, you know, it isn't seen explicitly on its face, discipline in a disproportionate way, but there can be ways that it is implicit in that, that the data shows us that there are, you know, people who aren't doing this necessarily maliciously, but there is a sort of bias that they might have grown up with or been exposed to, and that is influencing the way that they target certain subgroups of students. And so we really want to have trainings around those, especially for staff and administrators, and as well as other students, to just kind of understand the implicit bias that you might have and the impact of discipline on students of color. Second area here is social emotional learning. So this ties into the PBIS and restorative justice, but basically teaching students to recognize and manage their emotions. Laura talked about the restorative justice circles, sitting down, talking about what you want your classroom to look, sound, and feel like. That's something that I did with my students at the very beginning of the year. We talked about, you know, what does it look like to be unkind? What does it look like to be respectful? What does it sound like? What does it feel like? And really talking about these emotions, and at the very, you know, and having the buy-in from the students was very important to maintaining an environment where students could feel safe, safe enough to express those feelings in the classroom, and really develop those positive relationships that will enable them to really reach out if they do feel unsafe or unsupported, instead of maybe acting out in some way that could lead to a suspension or an expulsion. So the last thing on here is trauma-sensitive schools. So a lot of students experience trauma in one way or another. I had many students who would come to school one day fine, the next day all sorts of issues, and turned out that day they just happened to see an issue of violence at home. And these things can really affect a child's ability to control their emotions, pay attention, and learn while they're in school. So what's really important is for teachers to be able to identify this kinds of behavior and have training in it, training that I wish that I had to be able to help these students, instead of just having these kids be labeled bad or, you know, lazy or whatever it is, to really address those underlying needs that these students have. And you can see some links to areas you can learn more about this.
Okay, so we wanted to check in with you now, for those of you that are on, to see do the schools that you work with or that you're in or where your children are attending have any of these alternative discipline practice that we mentioned? Were there any practices that you wanted to share with us that were not mentioned? And what I'm going to do now, if I can figure out how to do it, is I'm going to, I'm going to change, well, I'm trying, but we're going to make it so that you all can, you can chat with each other. Here we go. Yes. Okay, so if you have any comments you want to share, everybody can now see them. And so first question is just, does anybody have anything they want to share about schools where they know are implementing these practices well? Are there any practices that you want to share that are not mentioned, or any good things you wanted to share with each other? You'll be able to see them below, so you can chat there, and we'll keep going, and just feel free to add your comments at any time in that box below. All right, how can you, if you want to get practices at your school, how can you do it? The good news is that in the last 2 years now, the way that we fund education has changed to more of an equitable formula, and we have a local process called the Local Control Accountability Plan. And in that plan, districts now must affirmatively address school climate, and they must talk about what they're going to do to help reduce suspensions and expulsions, and outline some goals and actions to improve school climate. And so we're seeing that a number of districts around the state are now doing more and more of that. They're investing in some of these strategies, PBIS and restorative justice and cultural competency and social emotional learning and training for teachers. And so we would encourage you, if you think that your school district needs more of this, that you should go. You should go to your school board meetings, and often this starts in about April. By July 1, the budget needs to be passed, or not July 1, yes, by July 1, the school board's budget and also their local control accountability plan must be passed. Before they do that, they have to have at least one school board hearing where parents can come and testify. Often districts, though, are having multiple school board meetings and meetings to talk about this. And you can always write letters and say, look, I want to see more of a focus on school climate. I'm concerned that young people are being removed from class or being suspended, and I know we can do better. I've been to my school and I know teachers need more help to support their students. I know we need more mental health counselors, whatever it is, and you can advocate. And there's a lot of tools. If you go to fixschooldiscipline.org, you can find a lot of tools for how how to actually do that advocacy and really see a lot of good work that's happening around the state to get more investments in social emotional learning for young people. And new research is really showing that without social emotional learning as a prerequisite, if young people don't have those skills, they cannot access their learning, and it's one of the top predictors of whether a young person is successful in school. So we have to address social emotional learning, and we need to do it with a fierce passion and with tools that are the most effective. And I see Jeff replied all and talks about a number of schools that he's seeing that are implementing pieces of this, and that Vallejo City is making great progress. And he's seeing that folks are actually doing restorative practice as a tier 1 approach and a tier 2 approach as well. All right, we're going to do very quickly on special education. We don't have enough time to give special education justice. This really should be its own training, and we will hope to in the future have a training just about students with special needs and discipline. So right now, for folks, I just want to give you a quick few things for you to remember if you're working with a student with special needs who is having a discipline issue and you're wanting to help them, or if your child is, has been affected by discipline and special education. So for students with disabilities that affect their learning, and their ability to learn, and who need special education and related services, they are entitled to some protections under the Individuals with Disabilities in Education Act. There are also young people who have a disability that affects learning that are entitled to a Section 504 plan to address those needs. So there are a number of ways that students with special needs can get supports. Right now, we're just going to talk about students with IEPs specifically, although some of the protections are similar. But the main takeaway that I want to say is that if a child has a disability, the schools must address any behavior that's impeding learning or creating those disciplinary problems, okay? And some of the type of help that you can advocate for through the individual education program process is for assessment. So you could advocate for a specific assessment to learn more about what's happening that the child needs for behavior, for a mental health assessment, for an assessment from specialists to try to find out why is this child having such a hard time with behavior in school. You can advocate to have a positive behavior intervention plan put in place, and this would be a plan that really, as it says here, is positive, and would be looking at what are the types of positive tools we can use that will help encourage behavior and reinforce positive behavior. There are different levels of placements that a child with severe behavioral needs might need. One of those is residential placement, and we put that here just because there are young people who have, even in a school that's implementing every single support and all the tiered interventions, it may not be sufficient. They may need a higher level placement. They may need a non-public school with really intensive mental health supports and education supports all combined together and really integrated. They may need a full-time residential treatment placement if their mental health needs are so severe. So just something that to know that is available. You can also get a medical evaluation. Okay, you can't, for under the IDEA, you can't actually have a doctor who's providing the services, but you can get a medical evaluation and also medication management. And then there are also the manifestation determination IEP. So if a child if there are a pattern of removals, if that child's being suspended multiple times for something that's very similar, right? So let's say every day they come into class and they're tapping their pen and they can't stay still and they're getting up and they're getting suspended for that. Then, and it's a pattern of removal and it's something related to their disability, then it's required for there to be a manifestation determination IEP. And also if it's more than 10 days of removals. And the importance of this, and there's a lot more to this piece again, but just the really important thing to remember is that the school district has to determine whether those behaviors are caused by their disability, right? Are these behaviors related to that child's disability? And if they are, they cannot change their placement or keep removing them, and they need to update that IEP and look into a functional behavior assessment to try to figure out what's happening. Okay, so that's the important thing. The changing the placement also could be, if they're up for an expulsion, we have to see, is this a manifestation of their disability related to the disability, or because we're not actually implementing the plan that we created to help the child with their behavior or their disability. It's a very quick, and there's a whole long training on this, but just to let folks know that these are some of the tools that are there, and really to try to, just for some basic advocacy purposes. All right, so if your child is a student with a disability and has an IEP, you can ask for a hearing in writing called a due process hearing. And if your child is up for expulsion at that time, the appeal itself is not going to stop those expulsion proceedings, but that timeline to go to a hearing, and you go to the hearing before an outside administrative legal body called the Office of Administrative Hearings, that is a fast timeline. And so if that hearing body says, oh, yes, this was a manifestation of that child's disability, then it will stop the expulsion process at that point. Okay. All right. The restraints, and I just want to mention this briefly as well, because the numbers are so high for students with disabilities, that 81% of all those young people that are being restrained in California are students with disabilities. So we have some laws about that. They can only be used to control unpredictable behavior that poses a clear and present danger of serious physical harm. And really important, it can't be longer than necessary, and the force cannot be more than reasonable, and it can't cause pain, denial of physical comfort, deprivation of one or more senses, and verbal abuse is also can be a form of restraint, right? So children, we've heard, some probably have heard the stories of, a child who's tied to a chair. That's not okay, it's not allowed. And in a situation where there has been an actual restraint, an IEP meeting should be scheduled, and you should be either creating or reviewing a behavior intervention plan, because a restraint is a very serious thing. And so we want to be looking to say, why did that restraint have to occur, right? Why did it occur in the first place, and what do we need to do that's positive and it's an intervention to actually to engage and try to prevent another physical restraint from occurring. All right, I'm going to skip this slide for right now, just because we're running low on time, and I want to make certain that we have enough time to do a couple of the hypotheticals with you. Foster youth. I don't know how many of you work with foster youth, but there's an extra very important protection that I want to make sure you know about for foster youth, which is that if they are actually facing an expulsion for any of those non-zero tolerance offenses, or if they're facing that change of placement in the IEP, right, if they have more than 10 days of removal, then the attorney for that child should be notified, and also the child welfare agency. They have a right to get notification, and the reason is because we want to bring them to the table to help. There's a whole other level of services out there for youth who are in foster care, and we want to make certain that those parties can be engaged and can be involved and also know about what's happening, so they can bring the resources of the child welfare system and the courts and whatever else is needed to hopefully create a support system for those young people in lieu of expulsion, ideally. Hopefully by bringing a multidisciplinary team around the table, everybody can work together to figure out how we can help foster youth, because foster youth are being disproportionately suspended, and foster youth have, by definition, experienced significant amounts of trauma, and so we want to be particularly conscious of their needs and trying to create trauma-sensitive plans for them. And an expulsion is just another rejection and another removal from school. So whatever we can do to try to create that team and support those young people and look at those root causes and keep them out of our juvenile justice systems and in our schools instead is what we want to be trying to do. For our youth on probation, also, they have some rights, and these are very important. Which is, first is that they have the right to immediately enroll, right, in that prior school unless they've been expelled. So if they've gone into the juvenile justice system, maybe because they got a referral from police for something that happened at school, we want to make certain they can get back in school immediately, because a lot of times when they're coming back, they may not have all their records, or there may be a holdup in the records that are coming from the school in that juvenile justice facility or that juvenile hall, and really important, they can't be denied enrollment because they were in that juvenile justice system. Okay, we had a number of cases where young people are going to the school, and because the school had heard that something happened and they'd gone into the juvenile justice system, they said, you can't come back here, you can't come back. And so you've got young people who really, in order to really to succeed and to stay, to not recidivate, and we don't want them on the street, and they were being held out of school for many days at a time, and it is also a violation of their probation if they can't get into school. So we want to make certain that the law is very clear that you can't deny that enrollment, and they also have that right to immediately enroll. They also have a right to these transfer of records within 3 days, and accepting credit. When something happens like this, we need to make certain that they get all those credits that they completed in the juvenile facility if they're coming back to their school district. So these rights are in place because we know that youth on probation have some of the highest dropout rates in the state, and many of them never re-enroll again after they've touched that juvenile justice system. So we try to put some extra protections here to make certain that they do. All right, some practical tips, and we're almost done here, but some practical tips for parents.
So I know we've been throwing a lot of information at you, but what are some things that you can actually do for your child as far as protecting their rights? One of the biggest things is developing a system, whether it's running calendars, something you can just kind of put in your notes in your iPhone, but just basically tracking all removals from the classroom whenever your child not just suspended but is removed from the classroom in any way, making sure that those are written down, the dates, the times, the people involved, and then also in that same vein, requesting records of your students as far as the suspensions as well, records of their, if they're special education, records of their IEPs. Know that if you do request these records, they must be provided within 5 business days. So make sure that they know that you know that, so that they can send it as quickly as possible. And the reason that these things are so important is not only for you to be able to keep track of it, but if the school is violating your child's rights and you do want to come to an advocate or an attorney, those are the first things that we ask for, we look for. And if you're able to kind of have those already ready for us, or even just some of them, that makes us or whoever the advocate is able to really kind of take your case in a faster, more efficient way, and really just get them the ability to be back in school as quickly as possible. And then the last thing on here is that if disciplinary concerns are escalating and your child is not receiving special education services, a request for a special education assessment can help preserve your rights. And what that means is that if the school is put on some sort of notice that there might be a disability or a need for supports in the special education, and they do not serve those needs, or then your rights are protected because they were put on notice. And so that's just a positive thing. All of these things are great for you to be able to do and will help preserve your child's rights. So the last thing I want to talk about is the importance of family wellness. So again, this is a lot of information. It's very overwhelming. There's a lot of other things going on in your life, and achieving family wellness is very important. What we mean by that is getting a support system. I mean, there are other people out there who are dealing with very similar things that you are dealing with, whether it's family, close friends, other parents at the school, the people who use them as resources. you definitely want to learn from what they have done, learn from their mistakes, learn from their successes, and be able to pull from those resources. You want to practice self-care. You want to make sure that within these overwhelming processes of hearings, expulsions, etc., that you're taking care of yourself first, because if you're not taking care of yourself, you can't take care of your child. And then maintaining a positive relationship with school staff. I mean, at the end of the day, most schools, teachers, administrators are there to help your child. And so maintaining that positive relationship will enable you to go through these things like conferences and hearings in a way that you kind of already have a leg up, because they understand that you are, you're all on the same page and that you want the best for your child. Of course, to the extent, you know, there might be a point where you feel that the school does not have your child's best interests at heart, and if they are violating your child's rights, there's definitely something you need to do, regardless of wanting to maintain a positive relationship. But yeah, first and foremost, try to maintain that positive relationship. And then basically, why have this kind of family wellness? How will this help my child? Again, the self-care, being able to be centered as a support for your child. If you're taking care of yourself, you can then be a stronger support for your child. And as you all know, your children, I'm sure, see you as a role model. They copy you. So modeling those positive coping skills for your child will really help them when they're dealing with those overwhelming stresses that come with school and discipline.
All right, so we are going to just do we have two little hypotheticals we wanted to do with you all, just to kind of try to synthesize all this information. So here's our what if, and again, you can still comment to everybody if you'd like to make a comment or you have an idea, and we'll walk through it too and give you our thoughts. So what if Sarah is 7? She is suspended out of school by her teacher for 7 days for talking back. First of all, is that okay? Anybody have an answer? You can reply to everybody if you'd like, and give you a second, and then if nobody wants to, we'll respond. All right, silence. Well, so that's not okay. First of all, it's not okay because you can't be suspended for 7 days in a row, right? And the second reason it's not okay is because talking back would fall under willful defiance or disruption. And Sarah is 7, so we can assume she's probably in 3rd grade or 2nd grade, and if that's the case, then under AB 420, she cannot be suspended for willful defiance or for disruption. So Sarah should not be being suspended, and she should appeal, and she should also ask, if she can, call someone to get help from the district. The district should know that that's not okay, and also she can file for a removal of it from her record. All right, the next one. What if Gabriella is 12 and her math teacher refers her to the office every day? She has an F in math because she just sits in the office, and she also has an IEP. So what can we do for Gabriella? First of all, can the math teacher refer her to the office every day? Okay, so the math teacher cannot refer her to the office every day, right? I mean, technically, if the math teacher referred her for a few minutes every day, she could probably do that, but you can't refer for more than 5 days for the whole remainder of the period, right? And again, that we really should have in place a system for other means of correction. So we'd hope that in that situation, because she's getting an F in math, that someone has intervened. She also has an IEP here, and under her IEP, she's supposed to be getting supports to address her disability. So you'd want to ask for an IEP meeting for this child, and you'd want to have the whole team come together and find out what's happening and put in place a system so that she's getting supports and accommodations, because her behavior issues are not being met, and she has a right to progress in her academics and to progress from grade to grade. And if she has an F, she's not going to be able to do that. So we want to put in place a positive behavior intervention plan. We want to see what supports maybe that math teacher's needs. We'd want to figure out what's a plan for Gabriella so that she can succeed and not be referred every day. And we'd probably also want to see if that math teacher needs some extra training and support, because a referral every day really does mean that we're denying a child educational instruction and educational rights. So there are tools for Gabriella and for her mom, and if it's really every day, remember that we want to look and see, is she getting removals up to 10 days total? And sometimes I've had clients who they've been removed for multiple periods, not for the whole day, but when you add it all up, it's really that pattern of removal that's getting up to 10 days. And so there should also be a manifestation determination IEP meeting where the whole teams get together and see if we need to put in place, do a real functional behavioral assessment and see if there needs to be a behavior intervention plan. So those are some of the tools for Gabriella and also for her teacher and some advocacy options. All right, well, thank you all so much for joining us. If anybody has any other questions, you can again put them in the chat box, and you can feel free to contact us through Fix School Discipline. There's a support tab there and a lot more resources that you can use and things you can learn about discipline and also about alternatives to discipline and how they're being implemented effectively in California schools, and also experts you can reach out to and others who can support you. So thanks so much for participating today, and we hope that you all have a wonderful rest of your day. Again, as we click out here, we hope that you'll fill out the evaluation so that we will know how we can do a better job next time. Thank you so much.